Welcome to Hull & Estates and Succession Planning, a series of podcasts hosted by Ian Hull and Suzana Popovic-Montag. The podcast you're listening to will provide information and insights into estate planning in Canada from the offices of Hull & Hull in Toronto. Here are Ian and Suzana.
Hi, and welcome to Hull & Estates and Succession Planning. You're listening to episode number 214.
Hi there, Ian.
Hi, Suzana.
How are you today?
I'm well, and yourself?
Good, thank you.
Fantastic. Well, we have got a busy fall, and we've been out and about doing some mediations and doing our caseload and so on. And one of the things that we keep running into and bumping into is managing expectations of the surviving spouse.
That's a good introduction to this podcast, Ian, because we are, as you say, seeing more and more of these kinds of situations where people recognize that there is a surviving spouse, but would rather not have to deal with what comes about as a result of that.
Absolutely. And so we look at this, and first of all, spouse, the definition of spouse, is in Ontario and in most jurisdictions is a broader definition than just simply a married spouse. But the spouse, or the person who is left standing in the relationship, has significant claims. And we've talked about those claims: dependent relief claims, succession law reform claims, that way, and the family law act claims. But what we wanted to talk a little about today is more about how do we deal with that reality, and looking at it from the perspective as the family members, the surviving family members, and looking at the perspective as being an executor. Because it is really we find a very important part of the process is managing that spousal claim. So first of all, let's talk about who's a spouse. Go ahead. Why don't you talk about when we think of spouses? What conventional wisdom is are we looking at there?
As you say, Ian, our definition is a lot broader than it used to be, and we're talking about married spouses in the traditional sense, and we're also talking about common law relationships that meet a defined period of time after which the courts will recognize someone as a common law spouse here in Ontario, and you may also be extending the claim to also the individuals who are in same-sex relationships who similarly have met the timelines for those kinds of relationships to be recognized at law.
Absolutely. So we've got this person who has left, and they're typically in a high emotional state when their spouse dies, whether it's a husband, wife, same-sex partner, and they are then faced with sometimes urgent financial circumstances, whether or not they have access to the money and so on, if the other spouse was looking after the money, and they go see a lawyer fairly quickly. And at some times, we find our clients who are on the other side of it, either the beneficiaries, the children of the deceased, or the executors, they get a little huffy about the fact that the surviving spouse has gone to a lawyer so quickly. But there are time limits that the surviving spouse is stuck with, and there's a good reason to go see someone quickly. Go see a lawyer quickly.
That's right. And that's even if you have a will that specifically provides for that spouse as well, because they want to make sure that they're protecting themselves right from the get-go. And so when we talk about timelines, we know certainly here in Ontario that it's a 6-month limitation period from the date of death within which to bring a claim for equalization under our Family Law Act. And then there's also a 6-month limitation from the date that you obtain probate or a certificate of appointment of a state trustee with or without a will, here again in Ontario, for which time you can bring a dependents relief application under our Succession Law Reform Act.
So generally speaking, you're looking at months, and that can turn into literally days. And most of us who have organized estate plans still have contingent liabilities out there. For example, tax liability, or maybe you're involved in a business operation, you've got an outstanding piece of litigation or something. So to crystallize what is really available for that surviving spouse can take, and often takes, more than 6 months from the date of death.
And factor into that a grieving period. I mean, you are really going to be talking about days at the end of it when it comes right down to that number crunching and when it gets done and when reasonable or rational decisions can actually be made.
And that's so true. The emotional side of it, you forget that sometimes. As a lawyer, you sort of think clinically, we'll get on with it. But it may be that, say, money isn't a pressing issue right away, that surviving spouse needs some time before he or she is ready to go sit down with a lawyer and to get in and take in advice as to what his or her options are.
That's for sure.
So, talking about the management side of it then, again, that's really what we wanted to touch on, because we are struck on the litigation side by the high emotions on both sides. And not to oversimplify, but as I say, it's typically the surviving spouse is devastated by the loss of a lifetime partner, or even a short-term partner, or a long-term, medium, whatever term partner, and the family are typically devastated by that loss, but are typically devastated and react badly to the gold-digging surviving spouse.
And just to give a little bit of context to that, I think when you call it gold digging surviving spouse, we're really looking at a situation where there's a step family members involved, and so it's a lot easier for a child to be adversarial against a step parent than their own parent. We've seen situations where even that has come up as well.
And sometimes the lawyers, through no fault of their own, just in the process of protecting the surviving spouse, aggravate the situation. And a letter that says, I want to see all of the assets, and I want to see any joint accounts, and I want to see any insurance policies, is perceived by the family or by the lawyer who's acting for the family as aggressive steps as well. And again, if they can sit back and just look at, and as I say, manage what the expectations of that person are versus your expectations in the context of the law, we have to accept the fact that there has been a general trend towards equalizing or more fairness for the surviving spouse. So those kinds of questions are almost always legitimate.
But not very well received in cases, because so many people will be focused on the intention. The deceased intended for you to get so much, and you should be happy with that. You should want to uphold that testamentary intention and leave things alone. But when you take the law and you intersperse that into with the intention and people's rights outside of the terms, the four corners of a will, it becomes a very different situation. And I think that's where we see the most of the tension that arises.
You're absolutely right. I mean, I think the intention expectations on both sides are the driving force on a lot of these lawsuits, because as you say, you've got black and white that says this is what dad intended and this is what the surviving spouse got, so they should live with it. And when the surviving spouse is not given anything, that surviving spouse is angry at typically at the deceased, who hasn't got organized. And when you sit back at it, and the courts will analyze it as they see fit, but a lot of the times the courts are sort of a little bit grumpy with these testators or these deceased who are not closing that loop. They can have this wonderful relationship, and if it's an end-of-life relationship or a long-term whatever, but they don't close the loop with, and especially with a non-married spouse. And in Ontario and most jurisdictions, you are still treated differently and preferred in some respects if you entered into a marriage relationship as opposed to a common law relationship. That's just a cultural diversity there that exists, and the law supports married relationships in many respects more than than non-married, and that's just the fact of the way the laws have evolved over time. So anyway, we've been really struggling with these, and we'll continue to. And what we try to encourage our clients is to get in that situation where a judge isn't going to be critical of you not organizing your affairs and not explaining your affairs to all parts of the puzzle before death.
That's right. And we also see a lot of tension, and you alluded to this at the very beginning, with the executors as well, because they've got the four corners of a will, and they've got the marching orders and the directions in terms of how to distribute this estate, and then suddenly when they're faced with these extraneous claims that they may or may not have expected, it does throw a curveball into the whole system.
Absolutely. So all we can do is tell our clients until we're blue in the face, get this organized as best they can so that we don't have to face these inevitable tensions without some parameters of realistic wealth being transferred to the surviving spouse and realistic wealth being transferred to the surviving family.
That's for sure.
All right, well, thank you very much, Suzana. It was great to see you again today, and we look forward to our next podcast.
Thanks very much.
You have been listening to Hall on Estate and Succession Planning by Ian Hall and Suzana Popovic-Montag. The podcast that you've been listening to has been provided as an information service. It is a summary of current issues in estates and estate planning. It is not legal advice, and you're reminded to always speak with a legal professional regarding your specific circumstance. To listen to other Hull & Hull podcasts or leave any questions or comments, please visit our website at hullestatemediation.com.